لا من يجمع المال ويلقى فيه أهوالا سنون العمر ماضية وكأس الموت قد سالا.
Dear beloved viewers, welcome back. Before we took a short break, I explained what an Islamic will is. I will also explain the basis or the proofs from the Quran and Sunnah that justifies a Muslim to have a will. And I also mentioned that when it comes to a debt and a will, debts have to be paid first before fulfilling the wish of the deceased on that 1/3, which we have the right, a Muslim has the right to only dispose 1/3 of his wealth to other people. So the remaining 2/3 he cannot say or transfer it to other people. He only have 1/3 which he can say how he wants or she wants it to be distributed. Now, as I said, we will now go into pillars of wasiyah. There are 4 pillars of wasiyah. One is the musi. This is testator, the person who is giving the statement to transfer ownership of his wealth to another person without any consideration after death, upon death. Now, this person needs to fulfill certain conditions which I will mention shortly. Another important pillar is the beneficiary. Musi lahu. Another important pillar is the subject matter, Musa bihi. And the 4th one is sigha, the offer and the acceptance. Now let us look at each of them and what Sharia requires. On the testator, on the musi, the person who is giving a will, he must fulfill the following condition. Number 1, he must have reached puberty, baligh. In other countries, like in UK and other places, they clearly specify the age, which is above 18. But in our Sharia, it is puberty. So he should have reached baligh, not a minor, to be someone who is mature. A second condition is musi, or the testator, the person giving a will, should be a person of sound mind. So this excludes those with some form or those who are completely insane. So a person to give a will should be someone who have a sound mind. The third condition is the musi should do it out of his free will, without coercion, without any force. He should do it as per his own will. So these are very important conditions that applies to a testator, a musi. Now, in case he is ill, because sometimes we forget to write our wills until we are very sick, to that extent thinking or having no hope of continuing to live. So if he was ill and he wrote it during that situation, and you know sometimes when you are sick, okay, you are not that very sober, someone might challenge the validity of that particular will. Now if this happens, if you wait until you are that very sick, okay, then you are putting your will at risk of it being challenged, because someone will say, you know, he was in anguish, he was in pain, so he was not thinking properly when he was writing and so on. Now if that case happens, then this will have to go back to the qadis, who will have now to judge or to determine whether that person who wrote the will, while he was sick, he was doing it with sound mind, with a good memory, and he was understanding what he was writing. So it is important here to note that it's good you write it while you are healthy, brother and sister. Another condition relating now to beneficiary. The person who receives the subject matter of wasiyah. And here we are talking about, as I said, a person can only give wasiyah for 1/3 of his property. So we are talking about that 1/3. You can say, who do you want to benefit? Now, it is permissible in Islam, you can say you want it to benefit an individual, or if you want it to go, we want it to go to an organization. There is no problem with that. Another important condition of the relation, with the relation to beneficiary is that the person or the organization that you are dedicating your 1/3 to of your wealth should be known. Should not be someone who is not known to those who will be executing your will. Another important condition that scholars have said is should be competent to own bequested property. Should not be someone that is insane, okay? Or if you give a will to an insane, then definitely you should also specify who is the person who will be managing that property for the benefit of that individual, that insane person. So it should be competent, okay? The musi lahu should be someone who is also of sound mind, etc. Now the subject matter, something that you can give out in a wasiyah, number one condition is it should be something of value. You don't give wasiyah of 1/3 of whatever you own of something that is valueless or insignificant. Okay, it should be something of value. Number two, it should be something which is capable of being inherited by your legal heirs, by your legal inheritors. And third, it should be something that is capable of being transferred after your death, either physically transferred or constructively transferred. Physically transferred should be now, it could be money, physically transferred, or it could be a cow and goats, physically transferred. But things like houses, it could be constructively transferred by way of a transfer of title, etc. So it should be something capable of being transferred. It should also be existing, okay, as one of the property of the testator, of the musi. You should not be giving a wasiyah on things which are not yours. It should be something which is yours. Another condition of the subject matter is it must be something that is permissible, okay, to be used by that person that you want to benefit from. Now this subject matter, it can be a usufruct or it can be object itself. By usufruct here it means you can give a wasiyah to say that I want so and so to stay in one of the rooms in my house. Okay, so he will be enjoying the usufruct, the benefit that is offered by that particular room, which could be maybe he will not pay rent, but he will have somewhere decent to sleep and to keep him or herself. Or it could be a total surrender of the whole thing. Now here it could be the whole apartment. You are giving it to the beneficiary. So it can be the benefit or it can be the object itself that is transferred to another person. Fourth condition on wasiyah is offer and acceptance. That the person, the beneficiary, should accept that room or that house which you are giving him. So that is very important, because if you even give a wasiyah that I want this or that to be given to so and so, and if he rejects it, he doesn't want it, then definitely he will not be forced to take it. Then it will come back to the properties that can be inherited by others. So the beneficiary must also accept. So these are the conditions and sub-conditions within, with regards to pillars of a wasiyah. Now, to conclude on wasiyah, there are things or situations that invalidate wasiyah, that makes a will null and void. One is if the testator, the musi, becomes insane. If he becomes insane, then it is a long issue here. It is a long judicial procedure that will have to be involved to determine whether when he was writing the wasiyah he was sane or he was insane. So it is important that if the courts determine that the wasiyah was written while the man was sane, it might take its effect. But if it is becoming ambiguous to determine that, and all of a sudden we get to find that the musi is insane, and we get a statement that he had given this will, and there is no clear way to determine at what time he gave the will, whether he was insane at the time of giving the will or not, then there will make the will a little bit problematic and hard to implement, if not void completely. Another situation that can invalidate a wasiyah is if the beneficiary dies before the musi. So you have given a wasiyah that a certain portion of your wealth should go to benefit a certain orphan or to benefit your friend, but your friend dies before you. So then automatically that cannot be implemented. Another situation is if the subject matter of the will becomes non-existent. Okay, you wrote that if I pass on certain property, which is one third, the thuluth of what you own, will have to be transferred to a person, to another person, or to a charitable organization. But God forbid it catch the fire, or there was an earthquake that it is destroyed. Okay, or if it was money to be given to them, but now this money that was set aside for them is stolen, disappear, or it catches fire, then definitely that wasiyah will not be implementable. Lastly is if the musi revokes his will, says, I have revoked my will, I have retracted my statements, and then that also invalidates a wasiyah. So dear brothers and sisters, we should take note of the pillars that needs to be adhered to when you are writing a will, and also we should take note that there are circumstances that can make a wasiyah not enforceable. Now, to conclude on wasiyah, the advantage of having a wasiyah is, number one, it makes it easier for your dependents, for your inheritors, to open the inheritance file through our court systems or qadi systems. Okay, it makes it very easy and quick and faster for them to move on with that process. So this is very important, but also it makes it very easy to know who are the legal heirs, what are your debts and who are your debtors, among others. Now the mistakes that some of us commit when we are writing wasiyah is we don't have witnesses. Wasiyah needs also to have at least 2 witnesses to witness it. So don't write a wasiyah without having 2 witnesses. Another important, another mistake that people make is failure to name the executor. A wasiyah should also name who is going to be the administrator, who will implement, execute that wasiyah once you are done, once you're dead. So it's important a wasiyah also to name the executor. Another important another mistake that people make is not mentioning that you want your estate to be distributed according to Sharia law. Now this is very important. If you don't mention, you don't select, because in Kenya we have two courts that can handle estates, then if one of the legal inheritors doesn't want to go through an Islamic court system, then it will make this file not opened, because it means there are quarrels among the legal inheritors. One wants it to go to Sharia courts, another one wants to go to the secular courts. And due to this mistake that some of us make, it has led to a number of properties in major towns here in Kenya, in other countries as well. The brothers and sisters are quarreling which legal system to follow, and because they can't reach an agreement and consensus, the property remains undistributed for years and years. They die, the children comes in, and it really complicates the whole matter of wasiyah and of inheritance. We have so many stories here of brothers who have passed on, and the legal inheritors are disputing with each other as to whether to go through Islamic way of distributing inheritance or to go through the secular ways. Now, since they haven't agreed among themselves, then the property stays without any tenants. Some of them, starts to demolish. I mean, to suffer so many damages, and nobody is going to take care of it. Wallahi, the essence of Islam having the law of inheritance and giving us this wasiyah is because Islam views mal as khair, as something good that needs to be handled for the benefits of generations, benefit of other people. Now, if we can't reach an agreement on how to distribute this estate, and then we simply look at that estate the way it stays, and if it is a building, it is not renovated, nobody stays onto it, it starts suffering damages, cracks here and there, and is not taken care of, it is going to demolish, it's going to break down. And at the end of the day, we lose a lot of wealth because of this kind of mistakes that some of the owners don't follow. So our Islam, our religion requires from us that we should be able to ensure that our wealth passes on to the next generation smoothly. And one of the way to do that is to ensure you have a will, and in this will it is important for you to clearly specify that you want your estate to be administered and to be run according to Sharia, according to the teaching of Islam. And with that, even if one of the legal inheritors or two or three of them are not okay with it, they can't do anything about it, because at the end of the day, it was not their property, it was your property, and your wish will have to be granted in the Qadi's court. And this is very important. And with that note, this is a brief discussion on wasiyah that we as Muslims needs to be well versed of. Now, last point here is, in as much as a wasiyah needs to confirm with these Sharia rules and conditions, it is important as well to seek the expert knowledge, the knowledge of the experts, the legal professional guys who will write it in a very formal way that will make it enforceable in either Qadi's courts or in any other court. So it is very important to also seek the legal opinions or to involve legal professional lawyers to draft or assist you in making sure that your will, it is something that is Sharia compliant as well as it is legally enforceable. Inshallah, we will end up here. Until we meet again, Assalamu alaikum wa rahmatullahi wa barakatuh.
إلى من يجمع المال ويلقى فيه أهوالا سنون العمر ماضية وكأس الموت قد سالا